polls. So the 5 pieces of legislation that we are going to look at relate to the gender pay gap. They relate to protected disclosures, the Sick Pay Act. They relate to the transparent and predictable working regulations that were passed in December, and to the new act around work-life balance, which there's been lots and lots of talk about. But we're going to start with looking at the gender pay gap. But before we start, we're going to put up 2 poll questions, and we're interested in your input to these 2 questions. So the first poll question, which you should see on your screen now or very shortly, is your organisation required to publish a gender pay gap report? And then the second question is, if yes, has your organisation started preparing its report for 2023? Okay, so is your organisation required to publish a report? And if yes, have you started your 2023 report? So I'm going to dive right in with Lucy, because there was lots and lots of talk about the gender pay gap legislation last year. There was lots and lots of work involved for any organisation that had over 250 employees, including Mason Hayes and Curran, who had to prepare and publish a report on the gender pay gap within the organisation by the end of December 2022. Now, this isn't a particularly new piece of legislation, but we thought this was an opportune time to remind ourselves about what it says and what the obligations are for employers, because it's a tricky piece of legislation and it's relatively new to us in this country. So my first question for Lucy is, remind us, A, what the gender pay gap is, and B, what the gender pay gap legislation does.
So in very, very simple terms, the gender pay gap is the difference in the average hourly rate of pay between male and females across an organisation. And this legislation requires organisations of a certain size to prepare a report on its gender pay gap across a range of metrics. They include things like the mean and the median rates, hourly rates of pay, but it also includes things like bonuses and also things like BIK-able payments.
CARS,
exactly.
VHI.
Exactly. So those organisations need to crunch the numbers, do their calculations, put their findings into a report, and then that report needs to go onto their website where it sits for 3 years. And it's an annual obligation, so it's not the case that you did it last year and you're off the hook. It needs to be done again this year.
And then to whom does this legislation apply? What size organization?
Yeah, I mentioned the threshold.
Yeah.
So for last year and this year, it's organizations with 250 or more employees. From next year, that threshold is going to go down. So it'll be organizations who have 150 employees or more. And the following year, so 2025, it'll apply to organizations who have 50 employees or more.
This is a massive undertaking, especially the first time round. So it's going to be a massive change for smaller organizations when the legislation expands to the 150 and the 50. What is the period that the organization has to report on?
Okay, so the employer can pick its own snapshot date, which has to be a date in June. So this session is very timely. And the reporting period is the 12-month period immediately before and including that snapshot date. And then the report has to be published 6 months later. So it'll be January. So for this year, or sorry, December. So it'll be December 2023 that this year's report has to go up on the website.
So the whole raft of reports published at the end of December last year, including, I have to say, including our own report. So Lucy, just for our audience, a couple of takeaways for the audience.
I think the number one thing is to start thinking about it now and to start getting ready for this year's report, because it's a huge undertaking to get this done in time for the deadline. And I would also say, don't assume that you do or don't have to make a report based on last year. So if you're one of those organizations that has seen a reduction in headcount in the last 12 months, it might be the case that you don't actually legally have to make a report this year. Although bear in mind that the threshold is going down next year. So if you have more than 150 employees, some employers might decide to just do the report anyway for consistency.
And that, Lucy, headcount threshold is calculated along with everything else on the snapshot.
Exactly. And then on the flip side, if you're an organization who's seen growth in the last year, it might be the case that you have to make a report this year for the first time where you didn't have to do it last year.
So they're your takeaways. Top tip for our audience.
Top tip would be to pick the same snapshot date this year that you chose last year, so that you're comparing like with like. Because otherwise you could be in a position where you're explaining differences in your report that are simply down to having a different reporting period this year.
Okay. We might just have a look at the poll results before we move on to our next topic. That was one of our shorter ones. So the questions again were, is your organization required to publish a gender pay gap report? 47% say no. 40% say yes. Okay, so don't know is something that organization, like for the 13% who are saying don't know, you need to look and see what the head count was on the whatever your snapshot date was last year, but say the 30th of June, because that's the most common one, whether your organization meets the threshold on that date to be required or to be caught within the scope of the legislation. And then the second question we had is, if yes, has your organization started preparing its report for 2023? So obviously not applicable for those who don't have to report, but yes, the work has already started by 33% of those who do have to do it. So that's interesting actually. And I think the fact that the work has already started for a report that has to be published next December is interesting and indicative of the level of work that is required here. And that is, I think, is largely driven by the fact that most organizations' snapshot dates are some place in the last 2 weeks in June, most commonly the 30th of June. And that's when the figures have to be kind of gathered with a review to reporting on them later in the year, but by no later, but then the end of December of the particular year. So one to watch and one to bear in mind, given the reducing thresholds over the course of the next few years. So the second piece of legislation that we are going to talk about is the Sick Pay Act, okay? And we're going to just put up 2 poll questions in relation to the sick pay legislation first. So the first poll question is, does your organization have a sick pay scheme? So for anybody who joined us late, if you scan the QR code on your screen, it will take you to the Slido app where we're managing our Q&A questions and our poll questions and results. So first poll question in relation to the Sick Leave Act is, does your organization have a sick pay scheme? Then the second question is, if yes, has your organization's sick pay policy been updated since January 2023? That's when the legislation took effect, and we're going to talk about that in a second. And if no, have you had to pay statutory sick pay to somebody yet in circumstances where you might not have paid any sick pay to date? So they're the 3 poll questions, and we'll come back to the answers in a few minutes' time. So this topic, Lucy, is interesting because we, for years and years and years, have been saying to clients that unlike other European countries, there's no obligation in Ireland to pay sick pay. Now, I'm not entirely sure that has always been understood, particularly in circumstances where, you know, for example, the public sector pays sick pay. It used to be for 6 months, but it's now 6 months full pay, 6 months half pay. But for other organisations, it was entirely a matter for the organisation, for the employer to decide whether they wanted to pay sick pay or not. Some of them did, some employers didn't. Those employers who did, you know, approach it on either an ad hoc basis, a completely discretionary basis. Some organizations have policies that provide for sick pay for a month or 2 months. Actually, that level of sick pay is quite common in the tech sector. And then other organizations, again, including our own, have a policy in place where we provide for sick pay for up to 6 months. And sometimes they're over rolling periods and there's conditions attached and all of that good stuff. But that all changed in January 2023 because we now have legislation that mandates the payment of sick pay in certain circumstances. So Lucy, tell us what the legislation provides for. Lucy's in the hot seat today.
I am, yeah. So the legislation says that employees who completed 13 weeks of service are entitled to 3 days paid sick leave per year. And the rate of sick pay is set out in the legislation, and it says that it's 70% of the employee's daily rate, up to a maximum of €110 per day. But it's interesting because once the employee meets that service requirement, so the 13 weeks, but they could still be in their probation period, there's no further waiting period. So the first day that they go out on sick leave after that 13-week point, they're entitled to be paid for it at that rate.
Unlike many sick pay policies that say you're not entitled to sick pay while you're on probation or in the
Exactly.
first 6 months or whatever.
Exactly. And another interesting point is that in order to be eligible for the sick pay, the statutory sick pay, employees have to give a sick note from a registered medical practitioner on the first day of their absence. So that's another difference to a lot of employer schemes.
Exactly, because a lot of employer schemes say you don't have to give a medical certificate for the first 2 or 3 days or whatever. And there's also that kind of little, what is it, a sucker punch, because it's a 60 or 70 quid exercise to go to the doctor and get a medical cert for most people.
Exactly.
Okay. And you said then 70% of the employees' normal pay subject to the cap. And I get that, but how do employers figure out what the normal rate of pay is, particularly for people who have regular hours or bonuses or commission whose pay goes up and down?
Okay. Well, commission and overtime, they are excluded from the rate, says that in the legislation, but things like regular fixed bonuses or allowances, they're all included in the calculation. And then in terms of the hours that people work and working out what the actual rate is, if you have somebody who is paid an annual salary, or they're paid an hourly salary, or an hourly, they're paid an hourly rate, but their hours stay the same, day on day, week on week, month on month, or whatever. The amount, the rate for those employees is the amount that they would normally be paid, so their normal daily rate.
Yeah.
But then you've got those employees who might be paid an hourly rate, but the hours change from day to day or week to week, and they're just not fixed. For those employees, it's the amount that they would have earned if they come into work on that day. And then there's a third category. So if you have some other way of working out an employee's pay, you look at the average hourly rate over the 13 weeks before they went out sick, and you multiply that by the number of hours that they were due to work. So, I mean, there's a bit of work in that calculation.
I think I need to lie down after that.
Yeah, exactly. But it's also important to remember that it's not the full rate. So once you do that calculation, it's not the full rate, it's 70% of that up to the max of €110. Yeah, exactly.
Which in some organizations is tiny, but in other organizations, €110 for a day's work is a lot, particularly for kind of people on kind of minimum wage.
Now it's the lesser of that, so it's 70% up to a maximum of 110.
Okay. And then something you touched on earlier, if an organization like us, for example, already has a sick pay scheme and a sick pay policy in place, how do the two interact? Does an employer have to pay both?
No, not necessarily. So if it's the case that an employer scheme is more favourable than the statutory one, when you look at it on a whole, well then the employer scheme will apply and the statutory one falls away. Now the legislation is quite prescriptive when it comes to figuring out whether a scheme is more favourable on the whole, and it says that you need to consider these things. So the service requirement before the sick pay scheme kicks in. So do they have to complete the probation period? Do they need to do a year's service? Some of them say that. Whether there's a lead-in period, so does the employee need to be out for a certain number of days before they get the sick pay? The amount and the length of the sick pay. And then finally, the reference period for the sick pay scheme. So is it the case that the entitlement resets every year, or is it done on a rolling basis over 4 years or more, or something like that? So I think it's not really a kind of one size fits all, well, if you do this, well, then it's more favourable. It's kind of something you need to look at on a case by case basis and kind of tick the boxes on each of those factors that are set out in the legislation.
And the 3 days per week now is going to increase. Sorry, 3 days sick pay per year, not per week. Per year, that's going to increase.
Yeah, that's the plan. So the plan is from next year, so 2024, it'll go up to 5 days per year. The following year, 25, it's going to go up to 7 days. And in 2026, it's going to go up to 10 days. But that isn't actually baked into the legislation at the moment. So each year, the minister is going to have to bring in new legislation to say that from next January, the the number of days is going up. So it's not automatic, it's something to keep an eye on.
Okay.
Yeah.
And given the efficiencies in the legislative process at the moment, it'll be interesting to see whether that actually happens or
Yeah,
not.
and I think it might be something that's brought in, sometimes you see these things around budget day, they might be brought in then. So that's around the time that I'd be looking out for it.
Okay, so your one takeaway on this statutory sick leave scheme and legislation?
I think the biggest takeaway is that it's payable from the first day that they're out, but also that they have to give a sick note if they want to avail of it. So it may be the case that actually some employees don't take it up because it's kind of a burden that they have to go to the doctor and pay the 60 or 70 quid to get the sick note.
And then your top tip?
Yeah, it would definitely be to go and have a look at your policy if you have one, not just this year, but next year and the years afterwards, to make sure that it's still compliant, and just in case there's any other kind of tweaks to the legislation when the days are increasing, just to make sure that you captured all of that. So it's something you need to look at over the next couple of years.
We say this time and time and time and time again. You have to keep an eye on your policies. You have to review them every couple of years. You have to communicate them, because policies are good to manner beast when they're in the drawer of the HR manager's office. Now, that's less common now with intranet and shared kind of platforms that employees are using, but it's a point that we find ourselves repeating all of the time, isn't it?
Yeah, absolutely. And it's the kind of thing that as they're updated, tell the employees, send out the email, don't assume that they're just going to see it on the intranet. Yeah. Tell them as they're being updated.
We're going to just have a look at the poll results before we move on. So the first question is, does your organisation have a sick pay scheme? Oh, wow. That's massive. I'm really surprised at that. So 91% of the audience here has a sick pay scheme in place. That's really interesting, actually. So if yes, has your organization's sick pay policy been updated since January? Yes. Okay, that's interesting too. So clearly people are very live to this statutory sick pay requirement. So that's interesting. And the final question is, if you don't have a scheme, so for that 9% of attendees who don't have a sick pay scheme, have you had to pay statutory sick pay yet? No. 37% of people say yes, they have. So that's interesting. So this is being availed of. It is being used. Maybe the 60 or 70 quid for the medical cert isn't an option, or isn't a deterrent. And I appreciate not everybody has to pay that.
Exactly. So I'm going to turn the tables now, Melanie, and I'm going to put you in the hot seat for a couple of minutes. And we're going to take a look at some changes to the protected disclosures legislation, or whistleblowing legislation, that took place last year. Before my seat gets any hotter, we might just have a look at the poll questions here. Yeah. So the poll questions in relation to protected disclosures, you should see them on your screen now, is, does your organisation have protected disclosures, i.e. a whistleblowing policy? Second question, do you have an internally publicised and clear channel for workers to report wrongdoings, so to blow the whistle if they want to, or if they feel the need? And then, have you ever had to deal with a protected disclosure? So we're dealing with some complaints in this area, and it kind of goes in swings and roundabouts. We seem as a team, and bear in mind there are 30 of us on the team, 30 employment solicitors. We either have loads of them going on or very few of them gone. So it is a kind of an interesting space. Yeah, absolutely. And I mean, we've had protected disclosures legislation, or whistleblowing legislation, in Ireland since 2014. It changed last year. There was new legislation that was brought in. We're going to talk about that in a minute, but before we get to that, can you remind us, what is a protected disclosure? So a protected disclosure is a disclosure of relevant information by an employee, now a worker. And relevant information is information which, in the reasonable belief of the employee / worker, when we'll talk about that in a second, tends to show a relevant wrongdoing. And then second of all, because there's two parts to this, the second part is that it came to the attention of the worker during the course of his or her employment. So what is a relevant wrongdoing? That actually hasn't really changed. There's been a kind of a small add-on at the end that's very technical, but just to remind ourselves, a relevant wrongdoing is that an offence has been committed, that a person has failed or is likely to fail to comply
with a legal obligation, and that's other than one arising out of the employee's contract of employment, but we'll come back to that again later, that a miscarriage of justice has occurred, that health and safety law has been breached, there's going to be damage to the environment. And I'm flying through these because these haven't changed, okay? There's been an improper use of public money, or there's been an act or omission by or on behalf of a public body which is oppressive, discriminatory, or grossly negligent, or constitutes gross mismanagement. They haven't changed, okay? What has changed is that it's now extended to a breach, and a breach is defined and it relates to specific pieces of European Union legislation, which are all set out in an annex to the amending legislation. And they relate kind of to things like public procurement, product safety, transport safety, environmental issues, those kind of things. So quite technical and listed in pages and pages and pages of an annex to the Act.
Yeah, and I think the purpose of that Act really was to protect people who blew the whistle, wasn't it? I mean, it was kind of to tell us what are protected disclosures, and then if an employee makes one, they're protected.
And that hasn't changed. That level of protection hasn't changed.
Yeah, so you might just tell us and bring us through what are the main changes with this new legislation?
So the biggest and the most important change is that employers are required to establish and maintain and operate internal reporting channels and procedures through which workers can make reports of wrongdoing. So that establishing, maintaining and operating a reporting channel, that is the biggest change, okay? Also, the legislation, which was applicable to just employees, has now been extended to workers, and the definition of workers is very broad. It's not just what you might think a worker is. It extends to the employees of outsourced service providers. So the catering, the maintenance, the customer service people where that might be outsourced.
Volunteers as well. That was a question that were always asked before. Did it extend to volunteers? And now it's explicit that it does.
And shareholders. And members and directors. So unbelievably broad, and applicants in relation to information that came to the applicants' attention during the course of the recruitment process. The legislation also gives us a little bit of clarity around anonymous reports, and that's something that we've struggled with for many years. What to do with an anonymous report. The legislation says that organizations don't have to deal with reports which are made anonymously, but organizations can. And I think it'd be a very brave employer who would decide to simply disregard the disclosure of a relevant wrongdoing just because it was made anonymously. The legislation also provides for and this is interesting, for the confidentiality of the reporting person. So if you blow the whistle in relation to something via our channel, that every effort will be made to try and protect your identity. But the legislation does then say that if the identity of the reporting person has to be disclosed for the purpose of investigating or dealing with the whistleblowing complaint, then that is okay, actually. So it's not absolute. It's not an absolute right of confidentiality. The legislation now places an obligation on public sector bodies to report annually to the minister. And it also establishes the Office of the Protected Disclosures Commission. Now, that appointment has been made. The new Commissioner of Protected Disclosures is Ger Deering, but he's actually also the Ombudsman. So he and the Director General of the Ombudsman's Office are now the Protected Disclosures Commissioner and the Director General of the Commission. So a bit of a mouthful. So it's kind of an add-on. They weren't kind of new roles. And I think there's only 2 or 3 people in that organization. And then the kind of the policy and procedure that will set out these internal reporting channels will also make it clear when an employee can and should go external to the organization. So to a prescribed body, whether that's the Data Protection Commissioner or the Health and Safety Authority, they're kind of the biggest ones that we come across on a daily basis. On when they should go to the Minister and when they should go to the Office of the Protected Disclosures Commission. Still a mouthful.
Wow. So, I mean, that piece of legislation is massive. It does a lot of things, brings in a lot of changes around this whole whistleblowing area. The first point that you mentioned there was around employers now having an obligation or being required to establish this internal reporting channel and procedure. Can you tell us a bit more about that? What is it?
So that should be a place, an email address, a telephone line, or a person to whom an employee can bring a concern. And this is specifically a concern of a relevant wrongdoing. So the channel to receive the report, that's the most important thing. Then there has to be a designated person to follow up. Now, that designated person might change dependent on what the report is of. If it's a report of financial wrongdoing, it might be a finance person or
if it's health and safety, it could be
exactly,
could be
exactly,
that,
exactly. So that designated person then has to acknowledge receipt of the report within 7 days. That's new, and then has to do diligent follow-up and feedback. So the diligent follow-up and feedback is also new. So the diligent follow-up is an initial assessment of the report. There may be a requirement to go back and seek further information. After that initial assessment, the designated person might decide there's nothing to see here, move on, folks, or might decide that there has to be a further investigation, or might decide that some action is appropriate to deal with this. And then the requirement is to feed back actually to the reporting person. So that's new, that's interesting. Quite unusual too, to have to feed back to somebody who makes a complaint.
And it's something that we'd often get asked. The employee who's put in their complaint, they're constantly asking, what's the update? What's the update? What was the outcome? And now there's this obligation.
And I think the kind of fallback position to date has been kind of, well, you brought it to our attention, we're dealing with it. None of your business.
Exactly, yeah.
And that obligation actually is to feedback every 3 months if it's going on. So it's not just a once, it's every 3 months.
Keep them updated.
Yes, yeah.
Yeah, so I mean, can you come up with a takeaway? There's a lot there.
My takeaways are easy, right?
Yeah.
Have a policy in place and be clear about the channel. Like most organizations should have that already. But from the 17th of December 2023, which isn't that far away, appreciate today is 21st June, summer solstice, but 17th of December, it's less than 6 months away. And from that date, this legislation will apply to any organization with over 50 employees. And that's any organization in the private sector, because it already applies to organizations in the public sector. And then make sure that the policy and procedure is very clear, is very easy accessible. So we're back to that, don't keep it in a drawer in somebody's office. That has to be communicated. And then be very clear about the procedure for making reports using the internal channels, the conditions for dealing with anonymous reports. That is something that should be in there. And then set out the procedures for an employee when an employee should go external. So to a prescribed person, again, Data Protection Commissioner, Health and Safety Authority, HICWA, whatever it is, or to the Protected Disclosures Commissioner. So they're my kind of takeaways.
And do you have a top tip for us?
I have loads. Top tips. Have the policy in place, takeaway, and it's also a tip, right? Here's my tip, okay? And I think it's an important one. Be very clear about what is not a protected disclosure, because I think that gets lost in the mix and in the panic of trying to deal with a complaint. It's not a protected disclosure if it deals or relates to the worker's own contract of employment. So that's not a protected disclosure. It's a grievance. It might be a complaint of bullying, but it's not a protected disclosure. Now there was some old case law about this, because if it relates not just to the individual employee, it relates to several employees and it's health and safety, it might fall in that category. But generally one which relates to the employee's contract of employment falls outside the scope of the legislation. It is not a protected disclosure if it's a interpersonal grievance or interpersonal issue between one or two or more employees. That is not a protected disclosure. It's not a protected disclosure if it's disclosed for the purpose of taking legal advice. And then fourth and most important, and this was already there, but I do think it's the one that gets forgotten most. It's not a protected disclosure if it was the function of the employee to detect, investigate, or prosecute that issue. So if the finance director discovers something that it's his function or he's been asked to go and investigate, that is not then a protected disclosure. And I think that's the most important thing. What is and what isn't a protected disclosure, and then have the policy in the internal reporting channels, because if you don't, the default for most people is to go outside and that then just becomes a mess. we need to move on.
Yeah.
But before we do, we might bring up the results of the poll. So the first question in the poll is, does your organization have a protected disclosures or a whistleblowing policy?
Yeah.
84% is, okay, that's good. We hear you very engaged people
Yeah, that's great.
in attendance today. The next question then is, do you have an internally publicized and clear channel for workers to report? 77. Okay, bit of a disconnect there between having a policy and not having the kind of publicized and clear channel. And it might be just that the policy isn't a bit clear. So that's clearly for that kind of 7 or 8% of people, of organizations who have a policy but don't have a clear channel. That's definitely something to go and have a look at. And my last question, or our last question then, was, have you ever had to deal with the protected disclosure? So only 21% of you have said yes. And that kind of tallies with our experience. I think because there's so many of us on the team, whatever we're experiencing tends to be a relatively good measure of what's going on in the market. And that 21% sits there or thereabouts, I think, with what our experience is. Right, we're going to move on to piece of legislation number 4. And this piece of legislation was passed in December 2022, and it relates to transparent and predictable working conditions. Just before we get into it, I'm going to put up the poll questions again for this one. So this is a set of regulations driven by our membership of the European Union, became law in, like I said, in December 2022, quite low key and under the radar, but still has resulted in, some interesting changes. So has your organization, first poll question, has your organization updated its template contracts of employment since December 2022 to reflect, I think, the changes provided for by these transparent and predictable working regulations? That's the first poll question. And then the second poll question is, has your organization reviewed its probationary periods as a result of the new legislation? So probationary periods are one of the issues covered by these regulations, and we're going to talk about that in a second. And actually, we're going to talk about it now. Lucy, what do these transparent and predictable working conditions regulations do?
Okay, well, you're right. It was kind of very much under the radar. It's a very small piece of legislation, but it does loads of kind of random things
Basically,
all over the place. Yeah. So some of the things it does, there's now additional information that needs to go into the contracts of employment. Things around training, pay, hours of work, and they seem small, but if it's not right, like in theory, the employee could actually refuse to work the hours that you ask them to. So it's important that you get those changes right. It changes certain timelines. So it used to be the case that the core T's and C's had to be provided within 5 days of the employee starting work, and then everything else could be given within 2 months. That timeline has now been reduced to 1 month. 2 months is now down to 1. It also used to be the case that you could notify employees of any changes to T's and C's within a month of them taking effect. That has now been reduced as well. So they now need to be told on the day or in advance of the changes taken.
It seems bizarre.
It's funny, but that wording is in a lot of people's contract that will tell you within a month of the change taking effect. So that needs to be changed now, or you won't be in compliance. Yeah.
Well, or you can leave it there and give them the month's notice.
Exactly.
But
for new
required.
Yeah, exactly. There's also a couple of big changes, and you touched on one of them, the probation period. So I propose to just talk about 3 of them. There is a lot in it, right? So probation period is the first one. There's now a limit on the length of probation periods. So for employees in the public sector, the maximum length of a probationary period is now a year. And for employees in the private sector, it's 6 months. Now, that period can be extended. It can be extended up to 12 months, but only in exceptional circumstances and where the extension is in the interests of the employee. So that's a big change. I mean, there was never a limit on probationary periods before. And in practice, they used to they could be extended up to 11 months, but
and we're still debating what is in the interests of the employee.
We are.
That remains to be seen, and probably won't be clarified until there is some litigation and some case law on it, because we have differing views about what's in the interest of the employee, but that's nothing new.
But I mean, it is interesting. The legislation says that if an employee is out on some kind of protected leave during their probation period, so if they're out on the statutory sick leave or parents' leave or anything like that, the probation period can be suspended and the time that they're out can be added on to the probation period. So that might be something that employers can use rather than extending, they just add it on.
So that's probation.
Yeah.
The second one then is parallel employment.
So this relates to exclusivity of service clauses. And as a result of this new legislation, the default position now is that an employer cannot stop an employee from working for another employer outside of their work schedule unless that restriction is proportionate and based on objective grounds. And those objective grounds, there's examples set out in the legislation, but they include things like, to preserve confidential information, to avoid conflicts of interest, health and safety grounds.
And health and safety, I think, would cover working hours as well.
It would. So, I mean, if you had a full-time employee who said, well, actually, I'd like to go and take up, another almost full-time job somewhere else, you'd say, well, you'd be over the 48 working limit. But I mean, you could have a part-time employee who wants to, take up work in a shop at the weekend or something like that.
Which is
it would
fine.
be very difficult to stop them from
and
doing
back
that.
to your original point, that goes to that clause that's in most contracts of employment that says you will work exclusively for us unless you have prior written consent from us to do something else. So that is something, again, might not need to be changed, but certainly needs to be looked at, because if that's a refusal, it needs to be justified.
Yeah, absolutely. And I think, I would recommend that you leave that clause in, but you tweak it a little bit. And then the employers can kind of deal with requests as they come in on a case-by-case basis, rather than having a blanket prohibition in the contract.
Yes, fine. And then the third issue, Lucy, is the right to request a transfer to more predictable and secure working conditions. Another mouthful.
Yeah, and I mean, so this is for employees who've got 6 months service or more, and basically they can make a request to transfer to these more secure hours. The employer has to respond within 4 weeks. They don't have to accept it. It's just simply a right to request. And if the employer turns it down, the employee can make a request on an annual basis, and the employer can respond, they can actually respond orally afterward, but we wouldn't recommend you do that. I mean, obviously you should be putting it down in writing so you have a record of any requests.
An email, fine. So your takeaway for this one, transparent and predictable working conditions regulations.
Yeah, unless your contracts have been updated in the last 6 months or so, they likely need to be updated now. And then my top tip would be, review the contracts, make sure that they're compliant, and also consider the practices around probationary periods. It's much harder now to extend them beyond the 6 months in the private sector. So something to have a look at, I think.
And if anybody asked us what's filling our days or what the queries we're getting in relation to this particular piece of legislation, it's around the probationary periods to a large extent, and obviously the changes then to the contract. So we're going to just have a look at our poll results just very briefly here. So has your organisation updated its template employment contracts since December 2022? Yes or no? Just waiting for the results to come up there. Oh, here we go. Oh, interesting. So only half of our attendees, just a little over half of our attendees, have updated their contracts. That might be something that needs a review and some consideration at some stage. And the second thing is, has this made any difference to your probationary period? So yes, again, so interesting that 43% either didn't know or haven't considered the probationary period, or else already had probationary periods that were shorter than 6 months and with no capacity to extend. Because actually most of the contracts of employment that we drafted prior to December 2022 provided for 6 months probation, but with a right to extend it up to a maximum of 11 or 12 months. So that's interesting. We're going to move on to the fifth and final piece of legislation that we're going to cover, which is actually the most interesting one. And if I take you back to our COVID times and that interview with Leo Varadkar when he was at Taoiseach with his lovely national remote working strategy under his arm, and then they produced this lovely glossy brochure that was up on the Department of Enterprise website. And then after that, so that was January 21, after that he issued his code of practice on the right to disconnect, which was a bit of, in fairness, I don't think anybody disagreed, it was a bit of an old damn squib. And then he promised legislation around the right to request remote working. And we've gone through several iterations of that legislation, through several drafts of it. And there was lots of concern, lots of pushback at the beginning, because it's a right to request remote working. It's not a right to remote working, it's a right to request remote working. And then there's been the various iterations of the legislation. The most recent draft of the bill, before the one that was passed, only had a right to request flexible working for parents, for people who were looking after people with very serious medical conditions. And then boom, the legislation was passed and actually goes much further than that. So we're going to talk about that in a second, but our two poll questions before we get into this particular section. So first poll question, does your organization have a flexible working policy? Some organizations do, some organizations don't, but we're interested to see what the response is here. And then, does your organization have a remote working policy? I think we all appreciate that kind of post-COVID, there is a lot more remote working going on. Some organizations have tried to bottom out what that looks like in a written policy, or the other organizations are still in that kind of, in the space of, yeah, we're doing it, but we're not quite sure where it's going to go or how it's going to work. So it's an interesting space. So back to the legislation, because it's quite meaty.
Yeah.
It's going to change a lot, Lucy. So set out for us in as simple terms as you can what the legislation does. And just to say, the act has been passed but not commenced. And we'll talk about that in a second. So what does the legislation do?
Okay, it does 5 things. It introduces 5 days of unpaid medical care leave for employees who've got caring responsibilities. That's entirely separate to the existing force majeure leave right that exists, and it's completely separate to the statutory sick pay that we talked about earlier. The second thing it does, it changes the maternity legislation to increase the time an employee can take breastfeeding breaks from 6 months up to 2 years. It also introduces 5 days of paid leave for victims of domestic violence.
It's a long time coming.
It is, yeah, it is. And then it also introduces the right to flexible working arrangements, right to request flexible working arrangements for employees with caring responsibilities. And it introduces the right to request remote working for all employees.
So we're getting most questions about the first 2. So that's the right to request flexible working arrangements and the right to request remote working arrangements. I just be clear, flexible working arrangements are about hours of work and can include remote working arrangements, but remote working arrangements are about where the work is done. So being done somewhere other than the organization's kind of normal place of work. You might just talk to us about those 2 issues in particular.
Yeah. And I think one of the most important things to remember, and it's something you touched on there, this new legislation doesn't create a right to work flexibly or remotely. It's simply a right to request it, not a right to actually do it. Employees are going to need 6 months service before they can start either the flexible work arrangement or the remote work arrangement under the legislation. The right to request flexible working arrangements is only for employees who've got caring responsibilities. So it applies to parents of children up to 12 years of age or 16 years of age where the child has a disability. And then it also applies to employees who have caring responsibilities for a person who needs significant care or support for a serious medical reason. And then there's a list of people who that applies to, but it's really, really broad. It includes children, parents, grandparents, brothers, sisters, husband, wives, cohabitants, and so on. So it's really big. And then the right to request remote work, that's for all employees. Now, there's going to be a code of practice on this. It's going to set out the best practice for making requests, what needs to be considered after the request comes in, the appropriate reasons for turning down requests, and so on. Now, the legislation says that the code will cover the right to request remote working. Mm-hmm. So that's the one that applies to all employees. It says nothing about having a code of practice on the right to request flexible working. So that's the one for caring purposes. But having said that, all of the information that's gone up online and on the WRC website and stuff mentions flexible working and remote working when it talks about the code of practice. So I think it's very likely that when it is published, that it'll cover both.
It'll cover both.
Yeah, I think so.
Okay, fine. So I'm just looking at the questions there. We have lots of questions coming in. So again, we're using the Slido app for the questions, and we're going to have some time to get to a few of them in a few minutes, hopefully. Lucy, what happens if an employee is not happy with the reasons his or her request for flexible working or remote working was turned down?
Not a whole lot.
Yeah.
Yeah. So the WRC is not going to be able to assess the merits or the grounds for an employer's decision to turn down a request for flexible or remote working. So if the employee isn't happy with the reason, there isn't a whole lot they can do. Now, if the employer is in breach of the technical requirements to manage the employee's request, the employee can go to the WRC. And in that case, the WRC can award up to 20 weeks remuneration for breaches that relate to requests for flexible working. So that's the one with for caring purposes, or up to 4 weeks remuneration in relation to requests for remote working. So that's the one that covers all employees. And the WRC can also order the employer to do something. So if the employer hasn't, given the notification and it hasn't set out like the reasons for the refusal, it can order them to do that, and it can also reward compensation.
So the compensation and the complaints are only about the process.
Exactly.
So the consideration, the timeline, all of that, not about the reason.
Exactly. Yeah.
And do we expect the reasons to be covered by the code of practice?
Yeah.
Yes. Okay.
Yeah. It's not in the legislation. We are hoping that it will be covered in the code of practice. Yeah.
So what about the timeline? Because the legislation has been passed, I said at the beginning, but it hasn't commenced.
So yeah, exactly. So when it was signed by the president back in April, the minister said at the time that he hoped that the first two parts, so that's the piece around the unpaid medical leave and the breastfeeding breaks, that they'd be in within a couple of weeks. That hasn't happened yet, unless it's been signed in while we are talking at the moment. So that hasn't come in yet. And then he also said that the other pieces, so the domestic violence and then the rights to request the alternative working arrangements, that they would be in early autumn. There was a public consultation on the code of practice that only ended on the 9th of June. There's going to be a huge amount of work in putting that together. So I think it's optimistic to say that we'll see it in early autumn. I think it could actually be later than that by the time we see it, but we're hoping for early autumn.
My hope too is that we don't get all swept up in the flexible and remote working and forget that actually this legislation provides for this paid leave to look after somebody in the family who's sick. So the kids have the flu or hubby's in hospital or whatever. Now it's unpaid. It's unpaid.
Yeah, unpaid.
And then
but it's paid for the domestic violence. It is
paid for the domestic violence.
And we're waiting. We don't have the rate of pay yet. There's been a lot of debate in the Dáil and in the media around what that rate should be. It's expected that it'll be the full rate of pay for those 5 days.
And the extension into the breastfeeding.
Exactly.
Facilitation, if you like. Okay.
Exactly, yeah.
So your takeaways, Lucy, in relation to the Work-Life Balance Act?
Yeah, okay. So the takeaway is that the risk of claims here, now in relation to those requests, it comes from breaching the technical requirements of the legislation, and there's a lot. I'm not going to go through them now, but just in terms of timelines and, what the employee has to consider and, stuff that needs to be set out in writing.
This is all the 4 weeks to respond to the request.
Exactly. And it's going to be expanded upon in this code of practice. So, I mean, if an organization has a remote or a flexible working policy, I think the takeaway is that they will have to be updated to comply with this legislation and the code, because that's where employers are going to get caught out on that technical dealing with complaints piece. And then in terms of a top tip, I mean, watch out for this code of practice, watch out for the date that the legislation becomes effective. I mean, if you are regularly receiving our updates, then keep an eye on your inbox, because this is something that we're constantly providing updates on. And if you're not getting our updates, you can register for those using that Slido app.
Good point.
Yeah, there you go.
Good point. Okay, we have truckloads of questions here and we have 6 minutes. So I'm not going to be able to get through all of them. We did very well. Oh, actually, the results of our polls before we go any further. So I need to go back up to the questions here. And so I'm looking down because I'm trying to figure out the questions. So the poll questions: does your organization have a flexible working policy? Oh, interesting. 69% of organizations already have that in place. 70% of organizations. Oh, 69, somebody's changing their mind, or other people are still answering. So 69 versus 31. That's interesting. So actually a written policy, that's higher than I would have thought it might be. And then does your organization have a remote working policy? So that's the second question. So 72%. Okay.
I expected that to be higher than the first one, because I thought that the remote working, that was something that might come in after COVID, that it would be that would be the one that we'd have in place.
I
That's
wonder if the
interesting.
answer,
Quite
maybe
similar.
we should have clarified whether that's a policy that's kind of
Written.
laissez-faire, like that it's a
Mm.
practice, or whether it's written. Yeah. Actually, I'm wondering, maybe we should have clarified that. Anyway, we live and learn. Going to dive into a few of the questions here. One for you, the next one's for me, but one for you, Lucy, right? So what happens if an employer doesn't comply with their obligation to pay statutory sick pay? What can an employee do about it?
They can go to the WRC, and the WRC can award them up to 4 weeks remuneration.
Okay.
Yeah.
Okay, so and that's
So it's
the usual
straightforward.
single complaints form that's
Absolutely.
filed online. I mean, a 10-year-old could fill it out. So,
Yeah.
okay, interesting. Cost a whole lot more, 4 weeks pay rather
Yeah,
than
3
the
days.
70%.
Yeah,
Capped at
exactly.
€110. Okay, the second question I'm going to go to is for me. When can someone make a protected disclosure outside of the organisation? That should be clearly set out in the policy, and the kind of it's not the fallback. I mean, the instinctive thing should be that the report is done internally and dealt with internally, unless the employee believes that the wrongdoing is done by somebody other than the worker's employer, and relates to something done by somebody outside of the organization or a different organization. The outside of the kind of internal reporting channels, there are prescribed organizations, prescribed persons, and I mentioned some of those earlier on: the Health and Safety Authority, the Data Protection Commissioner, HICWA, and then there is the Protected Disclosures Commissioner. So this is Gerard Deering's office as well, and that should be a last resort. And actually, if you drill into the legislation, he won't, and his office won't actually look at a protected disclosure. They just decide where it should be sent. So there is basically just a sorting office. Does it go to the prescribed person, so to the DPC or the HSA, or does it go to the minister or whatever? The legislation also makes it very clear that an employee can go to the minister, the relevant minister, if the worker is employed by a public body, if they've made a report and there's been no feedback, and nothing done that the employee or the worker knows about. If the worker has a reasonable belief that the head of the public body is complicit or implicated or somehow involved, or if the employee has a reasonable belief that they're of imminent and manifest danger to the public interest. So they're the circumstances in which an employee can go external to the organisation. And bear in mind, when an employee makes a disclosure internally, they have to have a reasonable belief that something is a relevant wrongdoing. Whereas when he or she goes outside of the organisation, that the facts reported have to be substantially true. So that is another interesting piece. We've a good few questions there, Slido, around the transparent and predictable working conditions. Can you see those ones? So the first one is, what could happen if we put in a longer probationary period in the contract?
Again, the WRC can, or the employee can go to the WRC, so they can go onto the WRC website, fill in the complaint form. The WRC can order that the contract be changed, so they can, kind of insert a shorter probation period, and they can also award the employee up to 4 weeks remuneration. I'm flying to, I see that another one here on sick pay mail. What if they don't give a sick cert? Do you still need to pay? No, is the answer to that one. Do we have to update new contracts rather than existing staff? It's for new contracts. So that's on the transparent and predictable working conditions. Do we have to update new contracts rather than existing staff? The answer is yes. But if the employee requests a new statement of terms and conditions, well, then you need to issue them a new one that's compliant with this new legislation.
Then there's another one here: right to request to transfer to more secure hours. So this is predictable working hours.
Again, yeah.
Does that mean that a fixed term contract employee can request to move to a permanent contract? And the answer to that's no, that's not what this is intended to cover. It's intended to cover predictable working hours more than the status of the employee's contract. Regarding probation period, should you no longer state in the contract that the probation is 6 months and can be extended by 3 months? Yes, is our view, because, well, sorry, assuming that this question comes from somebody in the private sector. In the public sector, it can be 12 months. In the private sector, the cap is 6 months and it can only be extended for the various reasons that Lucy articulated when she was going through what the legislation says. I mean, should we still have a right to extend it in the contract? It's probably actually, sorry, I said no, probably actually not a bad idea to still have the right there.
Yeah.
It's how you exercise that contractual right to make sure you don't fall foul of the
Well,
legislation.
I think the key thing is if you don't have, and I've never seen it, but that somebody puts in a probation period that's 9 months long or something, or I've seen sometimes fixed term contracts that could be, you know, a year or even 6 months, like that wouldn't be allowed.
And there's a disproportionately long probation
Exactly.
period.
So exactly, that's it. So
there is one final question here because we're at 12 o'clock, Lucy. Would you, and this is Lucy's kind of pet project at the moment, the domestic violence policy. So the last question we have in here is, would you recommend a policy in domestic violence leave are included in another policy?
I think it should be a standalone policy, and I think it's I think it would be an amazing thing to have a standalone policy, obviously, so that employees, you know what their rights are. But I think it also shows that as an employer, you know, you're genuinely, you know, standing behind and supporting those employees. I mean, the hope is that not too many employees within an organization will need to avail of it, but I think it would make a massive difference to that employee if they knew that their employer was.
And I think that's the point.
Exactly.
Yeah, this is a statutory obligation to provide these 5 days paid leave. But it's no good to Manor Beast if the employee doesn't have the wherewithal to know about it or doesn't know it exists. So
or doesn't feel that they can make a request. And I mean, if you're an employer who has the policy in place, it's more likely that the employee feels that they'll be able to come to you and talk to you about it.
And that policy specified to whom the employee should go.
Exactly.
And that it can be done confidentially and they'll have a safe space to do it. Okay.
Exactly.
Thank you to all of our participants. We've had a phenomenal response to this top tip session, and we've had a phenomenal number of participants and attendees. Thank you to everybody who put in questions with huge numbers. So we only got through some of them, but that's not unusual. After this session, you will get an email asking you for some feedback. If there are topics that you would like us to cover in a future top tip session, please let us know. There are some questions there I see around kind of binary issues in relation to gender pay gap reporting. So maybe that's something that we will pick up in a separate session. Thank you for attending today. We hope you learned something.